So thanks so much for coming. I'm delighted to be here. I've come to this conference a number of times over the years, and so I'm happy to come back. And special thanks to Dev Dada for inviting me. I am trained as a lawyer, but do a lot of technical work at the University of California and have advised both private clients and agencies about privacy and security matters. And so what I thought I'd talk about today is the things I've learned along the way, the different ways of framing issues, of presenting them, in hopes that they can increase your efficacy when speaking with regulators. So let me start in a different place, though. I'm working on a book on cybersecurity right now for my cybersecurity class, and so none of you would learn anything from it. It's really for my students. But the real pleasure of working on this project is getting to read all the literature in computer security, and going back to reports from even from the 1970s. This report that was authored by Willis Ware, one of my CS heroes, was extraordinarily prescient. And written in 1970, it has this little nugget in the very beginning of it. It's important to influence design of computers and so on, so that security controls can be installed before the fact and as an integral part of the system. So I would say that this is one of the things that regulators have finally figured out. Regulators are talking about security by design, privacy by design. Willis Ware was able to get his committee together and come to a consensus on this recommendation in 1970. So that's pretty impressive. Another paper from the literature that I read recently is astounding in its prescience. Written in 1979 by a lieutenant colonel at the Navy Postgraduate School. It's called Computer Security, the Achilles Heel of Electronic Air Force. It's filled with anecdotes that anyone, even kind of the regulators would recognize today about the pathologies of software development and the types of vulnerabilities that creep in and the difficulty of identifying those vulnerabilities and doing something about them. And so there's, I'd say, 5 different anecdotes that you read in the pages of this article, and then you could think of recent examples of these very same problems occurring over and over again. Interestingly, and the reason why I'm showing you this is that he motivates the paper with a hypothetical. And the hypothetical is that the KGB is giving a briefing. A KGB analyst is giving a briefing to his colleagues, and he says, guess what? The Americans have put all their most sensitive secrets into computers, and they kind of know that they're vulnerable. They, in the abstract, they understand that their computers are vulnerable. But absent verified examples of us breaking into those computers, they're not going to do anything about those vulnerabilities. And it's like, wow, he really had the hypothetical right, and I feel like this is what's happened in the commercial sector with cloud and a whole lot of other areas. We knew in theory that there were problems, but it wasn't until those problems found an actual execution that we were willing to really grapple with them and do something about them. If you're interested in reading this article, just email me and I'll shoot you my copy of it. It's a fantastic read. He talks about his tiger teams at the Air Force, what we'd call a red team today, and how they were able to break into everything, and how they would even find. He gives this fantastic example of how his team plants a small bit of malware into a defense contractor's system, and the defense contractor can't find it, even when told about it. Even when told, this is what we put in your system, they can't find it. And not only that, the defense contractor manages to replicate the vulnerability and put it into other systems. It's just astounding, totally worth reading. So in getting ready for this talk and having read these recent papers, I asked myself the question, why was it that Willis Ware and these other people, most of whom were tied into the military and the intelligence community, How is it that they had all these insights and it's taken us so long in the regulatory field? So when I say us, I mean the lawyers. Why has it taken the lawyers so long to figure out these lessons that were articulated 40 and almost 50 years ago? And of course, I think we're familiar with the problem. The overall problem is that computing is so compelling and so beneficial that we have to adopt it. We have no real choice. And because we cannot fully manage the security problems, we deny them. We say it's just normal. It's just kind of risk we have to accept. And we become resigned to them. I think there's a lot of examples of where this has happened in society. I think car safety is another example. For a long time, we conceived of car accidents and driver deaths as inevitable consequences of the car. We didn't conceive of the idea that more safety could be built into them. So what I thought about today to talk about is give some concrete examples of how we could overcome this denial and resignation to insecurity in the regulatory community. So I'm going to talk about the legal tools that regulators have. I'm going to talk about how the regulators think about their tools, what their kind of psychology is, and then finally how you might use your expertise to convince them to take action in areas where you think it is important. So a lot of what I've written about is the idea that consumer protection law, the body of law that we could call consumer protection law, has a profound information security mandate. So when we talk about the Federal Trade Commission suing companies for insecurity, it's not because the Federal Trade Commission has an information security law. It's because the Federal Trade Commission is using its general power to police consumer protection, basically the quality and safety of goods and services. And it's interpreting that body of law as imposing an information security requirement. So that's a bit like skiing on stilts, right? We don't have an FTC security law. Instead, we have this general body of consumer protection law. And so when the FTC takes action, let's say against Facebook most recently, or against a company for having inadequate security, it does so under the rationale that it has the power to prevent unfair or deceptive trade practices. And guess what? There's no real definition of what these things are. It's kind of a slippery definition. So they're separate theories. That's one important thing to think about. There's unfairness and there's deception, two separate theories. But unfairness is any practice or act that creates substantial consumer injury, right? So that doesn't even really hang much meat on the law because we could disagree about what injury is. But what the Federal Trade Commission is looking for is insecurity that causes substantial consumer injury. And some other elements here, there are situations where insecurity is unavoidable by the consumer. So that's a plus if you want to bring a case. And there's instances where insecurity actually contributes to efficiency or makes a product possible that otherwise would not be possible. So there's a kind of cost-benefit analysis in this theory of action. But the main thing to remember is if you want the Federal Trade Commission to intervene about some security practice, you have to convince a Federal Trade Commission attorney that the practice it causes substantial consumer injury. The other cause of action is deception, and this is an easier theory to use. It simply means a representation or omission that misleads an ordinary consumer and causes them detriment. So there are a lot of things out there cause deception in the world. And what the Federal Trade Commission has argued is that if you're a company and you collect information from consumers, reasonable consumers assume that you have some baseline of reasonable security. So a lot of what I want to talk about is what that might be. So some other kind of dynamics here. The Federal Trade, you read about the Federal Trade Commission a lot, right? And there was this recent case against Facebook. They only do about 15 or 20 cases a year, right? So that is not a lot of enforcement. When you think about all the companies out there, we have the GDPR approach. And my colleague's going to talk about GDPR in more detail, so I'm not going to say much more than to say that it's similar to the FTC authority in that it operates at a pretty high level of abstraction. The GDPR is what I would call a principles-based regulation. It doesn't tell you specifically what to do, but it asks you to jump over hurdles that are pretty high. So they want you to use your brain and decide, to make an active decision about what type of technical safeguards are needed for your system. And they should be tailored to the type of data you have, the purposes it's used for, and so on. There is a very interesting part of the GDPR that, the security part of the GDPR that talks about state of the art that I want you to keep in mind. And of course, there's privacy by design and default. Enforcement is one of the interesting issues in the GDPR. It's hard to track this down. There actually have been some pretty significant enforcement actions. A lot of people pay attention to the 50 million euro fine against Google, but in addition to that, there was a $100 million euro fine against Marriott and British Airways. Spectacular fine, I think it was 180 million euros. So the fines are ramping up, and that's going to be a key part of whether the GDPR is effective. It's important. I might have my slides out of order, but so let me just keep going. So on one hand, you have FTC law, you have the GDPR that speaks at the principles level. On the other hand, another kind of theme of what's happening in cybersecurity regulation are highly prescriptive rules that we see emerging from some sectors. I think the most consequential of them is the New York Department of Financial Services cyber rules. You can, if you Google these, you can find them. They're at 23 NYCIR 500. And this is the model where the regulator tells you very specifically what they want you to do. They want you to have a custom security policy. They want you to be doing pen testing and so on that covers this, that, and the other thing. And they want a pretty broad array of security incidents to be reported to the regulator. So we have, cybersecurity rules are moving in these two different directions. One of high principle, and then one of this high prescription. So those are the types of tools, those are some of the tools that regulators have to police cybersecurity. But when they police them in a political environment. So you leave the text of the law, what you think the law is, and you come to an environment where the regulators have to work within their institutions to bring enforcement actions. And there's a lot of really interesting psychology here. I think a lot of the regulators, and I'm going to be a little bit hard on them today, I think generally speaking, many of them don't understand information as a thing. I see them as, in my experience from working with the Federal Trade Commission for a long time, is that most regulators essentially are solipsistic. They use Facebook, right? And they love it. They're part of the demographic that actually uses Facebook, middle-aged men. And so their experience of Facebook is what drives their kind of conception of what these services do. And if they see ads that are misleading and so on, that's their evidence. There isn't a real demand to think objectively about how other people experience services. So one of the lessons here is that in engaging with whether it's Federal Trade Commission or state attorneys general who are very active in security and privacy, is that you have to think about their technology worldview and how they might be using, they might categorically not be using the services that you use. So they have no experience of them, they have no idea of how people could be harmed by them or manipulated by them. Another important point is that anecdata is just more powerful in regulators' eyes than data. Ultimately, like it or not, you have to conceive of an enforcement action before a judge or a jury. And judges and juries are moved, not by data, but by stories. So having a good story is powerful. And here, because I am a lawyer, I can pick on lawyers a bit. A lot of federal regulators fight with a glass jaw. They are really worried about losing cases. Because if they lose any case, their entire agency is burdened by that loss. It's not like a plaintiff's lawyer, where you're a plaintiff's lawyer, you lose a case, who cares? You bring another. But if you're the Federal Trade Commission, you lose a case, it affects every single enforcement action that you engage in. So as a result, there is a defensive posture. It's not as aggressive as, let's say, Department of Justice when it charges criminals. It's a different posture. And then the other thing is that lawyers fake it. Wow, they fake it. One of the powers of being a lawyer is showing up in a room and wearing a suit and scaring everyone by your mere presence. You don't have to do anything to get this power. You just have to show up and not say anything and people get scared. If you ask lawyers just a few questions, you'll see that they're faking it. They really don't have a good conception of the technology and so on. And I'm one of the more technically trained lawyers, but I tell you, I get fooled all the time. This is a really embarrassing one, but there's this idea, companies say, well, we encrypt data in transit and we encrypt it at rest. And so finally, I was always fooled by this. I always thought, oh, that sounds great, wonderful. Until one of my defense contractor friends said, listen, you idiot, our data are never at rest. I had never even conceived of that idea. And I think regulators are laboring under a lot of misconceptions about what security analysis does. So there's a lot of specious representations that if you don't walk through the consequences of them, they're not likely to understand. A great example, you could tell a regulator that we do a full source code review of our software to make sure that it has no vulnerabilities in it. But of course, that says nothing about implementations of that software and how it could be implemented in ways where it becomes insecure despite the underlying software being secure in the abstract. So with all that in mind, I look at what security researchers are doing, and I want to give some examples without picking on anyone too much because I admire what they're doing. This is Mudge's work at the Cyber ITL. This is a great, fantastic effort. They are testing a huge number of Internet of Things devices, and wow, are they finding they are insecure. So in one of their reports, they do this study where they analyze LG televisions, Vizio ones, and hardened Linux. And they show that when the software is finally implemented in these devices, that many of them are missing basic security measures. There's a report basically says, if you look at LG televisions, they're missing these basic protections against exploitation. Great. And I can kind of get why that's wrong, but I don't think regulators would kind of get what the problem is there. So finding vulnerabilities is great, and the people in this room understand what those mean. But for the regulator, I think there's some other questions that you could put in your papers. There's some other discussion that you can put in your paper that could be really useful. One, can you link the vulnerability to some demonstrably bad outcome? As in this vulnerability. So you might ask, who cares that LG TVs don't have ASLR? Well, you might care a lot, or a regulator would care a lot, if the caption of that chart said, the absence of ASLR led to X number of infections in the Mirai botnet, or something like that. That's the type of resolution they need to link this together. So other critical issues, recall that when you argue that a practice is unfair, the Federal Trade Commission will do a cost-benefit analysis. So inherently, in their head is going to be the question, oh, well, you're picking on LG because they made these televisions, but what were the alternatives? How much would it cost to properly design the software? And what were the trade-offs? So you could talk about that. And then finally, and I think this is pretty critical, is there any way for a consumer to know that the LG television is not as secure as the Vizio one? Is there any way? Are there any signals out there? I think the answers to that is no, but you could talk about what would the consumer, what is the logical chain of facts that the consumer would have to know to be able to make a decision based on this graph. And it's quite complex. And you could convince the regulator that no consumer would figure this out on their own. And as a result, the market won't provide the signals needed. Therefore, they should intervene. So I love seeing images like this of these kind of DNS outages, but I'm not sure what they mean. And I was thinking, if you were talking, let's say, about Mirai or another one of the big botnets out there, it would be really interesting to talk about it, not in the sense of the servers that were affected, but rather how many users were adversely impacted and for how long. And I'm sure there are numbers out there about the amount of commerce that happens on the internet at any given second. So, what does it mean if no one can make a purchase for 30 seconds? I think the number is probably really big. I think that type of information could be very powerful for regulators and the type of thing that could change their mind about bringing a case. Now I remember what happened with my slides here. Okay, so I wanted to talk a little bit about state of the art. And maybe you'll have comment on this too. The GDPR says that your security has to be state of the art. But of course, state of the art has at least two different meanings in American law. I don't know what its meaning is in Europe. Oftentimes when you hear state of the art, it is said from the perspective of an advertiser, and it's meant to mean the best possible, or the cutting edge of scientific advance. But more conservative, and when I say that I mean small c, or careful jurists look at the same term and they say that's not what that means at all. What state of the art means is state of the practice. This is what people do commonly, day to day. Having a handle on that type of nuance is important. And so the question I would ask, and I have some examples of this, is how might the security community articulate a state of the art? And in some ways it has done this. But you could also imagine how you could contribute to public policy by merely surveying companies about their practices and documenting what they're doing and what they're not doing to give regulators an idea of what is common business practice out there. I think this is true with privacy by default and design, and I'm going to give an example of something I did in the privacy realm. So this isn't security, this is privacy. The rules governing spam were recently reviewed by the Federal Trade Commission. So yeah, we have an anti-spam law in the United States. It's wonderfully effective. But I have ideas about how we could make the law more effective. I wrote comments in the proceedings that I'm trying to drive the regulation toward a place where people who send commercial email have to use a standard disclosure in text, because I want filters to be able to look for that standard disclosure so it can be filtered. Okay, so among the things I'd looked at was readability of commercial email. And one of the things you'll see is that one of the deals, one of the bargains of commercial email is that spammers are allowed to spam you. It's an opt-out system. So every business in the world is allowed to send you email. And the bargain is that you have the right to opt out. Well, okay, to have a right to opt out, you need to know how to do it. And so I did a survey of looking at different spams, and what I found was that a lot of that commercial email is unreadable in a technical sense. So here's an example from Indochino. This is a company I love, like mainstream company. But when you get the unsubscribe, this is the unsubscribe right here. It's kind of like gray on gray. And so what I wrote to the Federal Trade Commission is this email has a background color and a text color that is so similar in hue that the ratio, the contrast ratio is only 1.6. And so the standard is supposed to be 7 for something to be readable. To give you an idea, this is basically unreadable. And if you have any type of visual impairment, you can't be read. So I wrote, it fails all standards for adequate reliability. And then I put in this last sentence, for reference, white on white would have a contrast of 1. So that's how close it is to just being white on white. So I thought this was an example of what we might be able to do in security, and that is to show examples from mainstream companies, not by fly-by-night companies, who cares, like mainstream companies, what's going wrong, compare those practices with a commonly recognized standard. So disability groups use this standard to argue whether something is readable or not. No one really argues no one argues much about it. I put in a conclusion, right? This isn't readable. No matter what standard you use, it's not readable. And then I put in this like reference to give you an idea how bad it is. It's almost white on white. Okay, I thought this was a pretty compelling argument, right? The FTC should go with me and pass a rule saying that when you do an opt-out, it has to at least be readable. Well, they didn't. And what they said was, none of the comments, and they're referring to me here, provide the commission with information about the cost and benefits of these rule changes. So I thought this was a little ridiculous. I didn't think I had to say that it doesn't cost any money to change F5, F5, F5 to FFFFF, right? But apparently I did, so I didn't follow my own advice. The lesson here is especially in the Trump administration, one has to talk cost benefit, even when you think it's ridiculous. So when a vulnerability is introduced into software based on, let's say, a lack of a flag, let's say when they compiled the software, they didn't put in a single flag, and typing that flag in would have taken 10 seconds, you should say that. It would have taken a competent engineer, 10 seconds to change this setting and make this software more safe. They want to hear that. I can't believe that this was their response. Another question that I want to challenge you on is the problem of expressing norms. So for my cybersecurity course, I interviewed a whole bunch of different experts who talked to my students, and I interviewed one of the graybeards, one of the wonderful people in CS, and I asked him, a series of questions, and one of the things he responded was, we in computer security, we know what we need to do. And I listened to that, and it was great. I believe you, but that type of argument will not convince any regulator. So I don't know if I tripped my slide here. So the types of things, this kind of appeal to authority, we know what to do, is too vague. I think there's other things that you can do as security researchers. One is to talk about fixes in engineering time. So we think it would take this many minutes to fix this problem. To talk about things like, if the problem isn't fixed, and at design, how many transaction costs and other costs are imposed if it's fixed after the product or service is in the consumer's hands? So this is an argument about ex post or ex ante interventions. It's almost always a better deal, right? If the service is fixed before the product goes into the marketplace. Are there tools to detect or fix the flaw? You might even show them the specific way the flaw could have been fixed. So for instance, in my spam comment, I really wish I had pasted in the HTML and written the fix. As banal as that would have been, I think it would have been a better way to express that change. And then maybe you could talk about trade-offs. You know, what are the possible reasons why a vulnerability remained on a system, or what are the possible reasons why it remained insecure in the marketplace? There's a number of things you can do to make regulators' jobs easier. One, I think would be really neat if, let me, before sharing this recommendation, let me give some background. If your client or if your company has a consequential security breach, you'll get a call from the Federal Trade Commission or from a state attorney general. They call up and they say, we want to know what happened. Tell us what happened. In those conversations, they're trying to decide whether or not they should bring a case against that specific company. And more often than not, they don't. So they're screening many different incidents to decide which ones to pursue. I think it'd be really useful for people in this community to create checklists of the types of questions lawyers should be asking technical experts. So this would be a deposition checklist in normal parlance, but you could also imagine specific ones for, let's say, security breach. The other aspect where I think there's been a pretty effective research-based information transferred to regulators is occurring in standards. So if you talk to the Federal Trade Commission people about what are the types of security breaches you decide to bring lawsuits for, like, you know, why did you sue Equifax and not another company? Well, size and damage and so on. But one of the main things they look at is the OWASP vulnerabilities list. And the Federal Trade Commission even says this in their reports, that the OWASP standards are important to them. And then here in California, when Senator Kamala Harris was Attorney General here in California, she did something really interesting. She collected data on all the security breaches that occurred in California that were reported to her office. And what she found is that if you looked at the root causes of those security breaches, many of them would have been prevented if you had applied the former, you know, the so-called the CSC controls. And if you look at the Attorney General's guidance on reasonable security, what they've basically done is they've copied and pasted the CSC controls. And that is what they consider reasonable security here in California. And finally, I'm gonna end here, in part because I'd love to hear your feedback on this last point. You know, security breach laws came out of Berkeley. They were an invention of Deirdre Mulligan. She had this idea that if we had to report security breaches, we could get public data about insecurity, and maybe we could do something about insecurity. Well, when those laws were conceived of, we had no idea how many incidences and breaches were actually occurring. In fact, I think everybody was surprised by the number that were actually occurring. But the other interesting dynamic in security breach notification law is that it's really about identity theft. You think about it, like what information triggers a security breach? It's social security number, credit card number, and so on. Well, that's because when that law passed, that was the only harm that the legislature thought was serious enough to justify breach notification. Now, that doesn't make any, I mean, now we know that that doesn't make a lot of sense anymore, right? There are many consequential security incidents out there involving intellectual property, trade secret, that you don't have to disclose unless you're a publicly traded company. And there's other things that happen out there that aren't covered by security breach notification laws. And so what happens now in practice is that for instance, when a client comes to me and says, we've had something happen, I say, don't call it a security breach. It's not a breach until we have legally determined that we are required to give notice. We're going to call this a security incident until we fully investigate it. And here's the real problem. There are incidents that are far worse than any breaches, right? I mean, so just imagine if a search engine company lost all your search strings, that would be pretty painful. It would be pretty embarrassing, probably more embarrassing or more problematic than if a search engine company lost your credit card number. I mean, at the end of the day, you're insured, right, against credit card losses. But search engine strings aren't covered by security breach laws. They're not a breach. They're an incident. And there's many, many other examples like that out there where websites, including websites that have very sensitive content, have incidents and lose their entire user database. And they don't have to give anybody notice. So I want to invite you to think about how we might broaden the aperture of what we consider consequential security events, maybe for reporting purposes, maybe to talk to regulators about other areas where they can intervene. So with that, I'd love to take questions, or we could 10 minutes? Okay, great. And I'd love to hear what you think about some of this critique. Yes, please.
Hi, I'm Leah Kistner. I'm the Chief Privacy Officer of a startup called Hoofnagle, but I used to be the global lead of privacy tech at Google. So I've talked to FTC people before. The thing that I wonder is, you're talking about, hey, let's go make a deposition checklist for lawyers. Why are we not sending engineers in to go and try and find these? Because I love lawyers. I worked with lots of lawyers. Most of them are not as good at finding problems in a system as the teams of privacy engineers that I've trained.
Yeah, what we're working on at Berkeley is we're trying to train the next generation of what we call public interest technologists. And so Ashkan Soltani was one of my students, and he was at the Federal Trade Commission, consulted on these cases. He had consequential findings. I mean, he was the one who figured out that there were all sorts of pictures in Facebook that you could reach through their CDN. That were not password protected, and so on. And those totally escaped the lawyers. So I agree with you. And so what we've been struggling with is finding people who can really do the technology and convince the regulators that there's something important in their findings. We need many more people like that. Any other questions or critiques? Anybody want to yell at me and argue about what should the regulators be doing that they're not? The types of things that you think are important or consequential. Dev, do you?
I don't want to yell at you. Great talk. Thank you. I think you talked about explain the in the cost benefit, like talk about the cost to add the mitigation, add more security. But if they're doing the benefit analysis, how do we argue about the benefit of turning on ASLR, or the benefit of, like in some cases I agree it's easy. I think like the unsubscribe from spam case, yes. But it's like, what is the benefit of because I think that's one of the things the community also grapples with is it's hard to measure security. It's hard to really say this significantly improves security outcomes. And so if we do that now, will we get stuck on benefits or?
Yeah, that's a great question. I think the anecdata is is more powerful. And so the examples I would give is, can you point to specific botnets that spread as a result of that protection not being in place? If you can't, it might be that that's just not the intervention that the regulators should be pursuing.
Eric Gross, another former security person from the big search engine. When I hear it would take only 10 seconds to insert this compile flag, of course, I think, yes, 10 seconds to type that flag, another 3 days to debug the messages that come from that, and another 3 months to actually deploy it. So I come from a perspective wishing there were some way to use market mechanisms instead of tricking regulators into causing good things to happen out there. Sometimes the tools that I would hope would help inform the market mechanisms entail some kind of legal risk, either to the companies involved or to the people publicly complaining about the companies and then getting sued for libel or whatever. Do you have any legal thoughts on improving the market mechanism?
So one of the reasons why I'm a fan of Mudge in this project is that the idea is, Consumer Reports since the 1930s has had people wearing lab coats testing whether doors open well, right, and so on. And so they're now going to be looking at the software. So I think that's important, but I definitely don't think it's enough. I think it's the first step out there. An interesting problem with Consumer Reports is if you look at their average reader, they look like me. It's a white dude with gray hair. So we have to not only, I think we have to get the signals about quality into the marketplace, but we also have to make sure that they reach down to other types of consumers. Thank you.
Hi, Matthew from the University of Bonn in Germany. You asked for feedback what regulators could do. I think one awesome thing would be to work more closely with the usable security community.
Yeah.
And tailor the regulation to what humans can actually do. So living in Germany, I'm on the receiving end of GDPR, and it's pretty horrible. Yeah. So it's great on the fining companies for data breaches. It's pretty bad on the side of informed consent, because they basically, the companies design things in a way that basically you are forced to consent to everything they want, because otherwise it's just too much work. And anybody in the usable security community could have foreseen that and help regulators prevent that from being a legal option.
I think that the cookie notice and the cookie notices are quite tiresome.
They are horrendous.
I've helped a lot of clients deal with GDPR, and I'd say that 95% of the compliance effort is under the hood, and the consumer would never know that they stopped collecting X, Y, and Z. What I've seen with a lot of clients is they've never had a data retention policy. So GDPR is the first conversation you have with many companies of like, so how long are you going to keep this? And then another big area where I've seen a huge amount is the decision to secretly do face recognition. I think one of the kind of secrets out there in the Valley is that if you give your photograph to any service, they're running face recognition on it. They may or may not tell you, and they may or may not tag. The GDPR has tamped down some of that opportunism.
So don't get me wrong, GDPR is fantastic. I'm just saying those parts where you're interacting with humans is horrible. So that's where I think there could be improvements with research we offer.
Yeah, actually, I'm wondering what you think about this, because to me, I think the ICO, the UK ICO, led with this cookie disclosure that I thought this is not what the GDPR is trying to do, but they led with it and signaled that it was okay. And maybe there'll be reform along those lines. Do you have a comment on that?
Yeah, the ICO was criticized.
That I thought this is not what the GDPR is trying to do, but they led with it and signaled that it was okay. And maybe there'll be reform along those lines. Do you have a comment on that?
Yeah, the ICO was criticized for not being compliant with its own websites until very recently. And I'm just reporting this from the press. I'm obviously not taking a position on what colleague data protection authorities are doing. And when they reviewed their guidance on cookies, and then they decided actually to become compliant with their own guidance, and so they are giving credit for that. And it's actually, I'm quite surprised that I find more and more websites who have decent cookie pages. So some still have the old style thing, oh, we do cookies and that will be all good for you, just admit that it will be all good for you. But now I've encountered plenty of websites personally where you see the technically necessary cookies. I mean, it's still a question whether that's still state of the art, but then performance, personalization, tracking, targeted advertising, cookies can be switched off one by one explicitly. And there's tools out now from commercial companies who are offering that, and it's taking more and more. And I see it mostly with companies who don't depend on tracking and advertising revenue. So, I mean, those who depend on tracking and advertising revenue, of course, are reluctant to make the change. But those who earn their money in a different way by selling airplane tickets or hotel bookings or so, they see that they get better customer relationship when they are transparent and actually respect choice. So I think there is a change ongoing, which is, I mean, we're just a bit more than 1 year in the full applicability of the GDPR, and this is going better than I was expecting, to be honest, because maybe I'm a bit cynical and pessimistic in that respect.
Yeah, those dialogues I find them frustrating, and if you just press X to get rid of them, they treat that as accept.
Yeah.
Important design error. And I think I have one question and then hand it over. Okay.
William Simpson, Daydreamer. Also lifetime subscriber to Consumer Reports, and I own an LG television, and I can tell you, because I looked at all of their software, that in fact they're running Linux on top of RTOS. They could have had all the security features, they just didn't turn them on. We gave the FTC Dave Farber, and then Steve Belvin, who usually attends here. Farber does occasionally. And during his first few months there, I went and visited Steve, so I already knew you only take a few cases a year, which is really terrible. But I could talk about a lot of this stuff, but the main thing is there is no private right of action, okay? Is that, yes, the federal government or state governments, they have some amount of limited resources. But without a private right of action for the people who actually have been affected by bad software or bad access points. I mean, we've known about distributed denial of service attacks since 1996, and we predicted them, had papers in 1991 and 2, okay, before they even occurred. So this is not news. Yes, the identity theft has something to do with money, and so that Congress can say, oh, it might affect somebody financially, but in fact, all of the kinds of the Mirai botnet, they affect you in every way. They take your bandwidth from your home, those are all losses. But without a private right of action, the real problem is we don't have good enforcement mechanisms. We have perfectly good definitions for many things, but there is no good enforcement mechanism. I like the fact that GDPR, I love lots of things about GDPR, not the fact that you can only say accept about their cookie policy. But the is that it can be the fine can be up to 4% of the gross revenue of the company. That's a serious fine, as opposed to the slap on the wrists that most of the stuff that we get now. If they're going to take 20 cases a year, they should be going for 20 cases a year that cause the companies to go near bankruptcy, so that they send a signal to all the other ones that they need to take security seriously and hire more security engineers, obviously, and in that way improve the whole ecosystem. But a private right of action might also be very helpful because informed consumers are the ones who are more likely to be able to be active and give good stories that the courts and the legislatures will understand.
Let me say briefly that the California Consumer Privacy Act does have a private right of action for certain security breaches. So it takes effect on January 1, and it's going to be quite interesting.
I am afraid there's no time for another question. Brief comment, 3 words. Can you make it?
Do you need slides?
I thought it was ironic that you compared LG and Vizio and showed LG to be more secure without pointing out that,
Opposite.
or less secure, without pointing out that of the 2 companies, Vizio was the one to actually be sued by the FTC for deceptive practices.
This is going to be really interesting. I think what Mudge and company are doing is really important because as they compare these different vendors, some of them are Federal Trade Commission defendants, and a real question is going to be whether those defendants are any better on security. That's going to be super interesting.
Okay, thank you very much, Chris. Let's give a warm applause to